Oh, it's refreshing to watch a federal judge who's been affirmed by the United States Supreme Court act like the drill sergeant at boot camp that she is. Because Judge Zinnes last night at a hearing told everybody on the Department of Justice and Trump's side to drop and give her constitutional compliance. Buckle up. Her words, not mine. We're going into 2 weeks of proctologist-style discovery, expedited discovery. She told everybody in the courtroom she's working 24/7. She expects them to, as she considers whether to hold the Trump administration and the Department of Justice in contempt for doing, in her words, absolutely nothing to get the Armando Abrego Garcia, who's been wrongfully imprisoned for 30 days plus in El Salvador, back to the United States, despite being ordered by 13 different judges to do so. They haven't done a darn thing, and that pissed off the judge, and I love to see it, and I'm here for it. So are you here on Legal AF. I'm Michael Popok. Let's dive in. We had a big hearing yesterday, and I see the corporate media doesn't know how to report on it. Maybe it's because a lot of them aren't lawyers. Some of them said, well, she held back on rulings on contempt. No, she didn't. She did exactly what a federal judge should do. She demanded answers. She didn't like the responses from Drew Ensign, the lawyer for the Department of Justice. She didn't like the filing that he made about half an hour before the hearing, in which he tried to substitute real evidence about where Abrego Garcia is and what the government has done to try to get him back, which is absolutely nothing, according to the judge. I'll read to you from her new order in that regard. And they try to substitute, well, we have the unofficial transcript of the press conference that happened inside of the White House. Everybody saw it on TV, Judge. She says, that's not evidence. We're going to run this like under the federal rules of civil procedure. I want evidence. I want sworn declarations. Don't hand me an unofficial transcript. And from what I can glean, from what I understand about that press conference, there's been no attempt whatsoever to demand the return of Abrego Garcia. What do you think the word facilitate his release from an El Salvadoran prison means? Which part of that don't you understand? And Drew Ensign said, consistent with the new Pravda of the Trump regime, well, we think facilitate means we just do on our part, on the domestic part. If he wanders in, I'm not making this up. If he wanders in to one of our ports of entry, like on a ship, he's like a stowaway, or on a plane, well, we'd let him in. But then we'd immediately deport him and remove him to a country not named El Salvador. We don't think he's entitled to a removal order. She says that's already been litigated. She said at the hearing, that's been litigated. Supreme Court already sided with me. The only question left is the remedy for the violation. But you violated. How do I know? Because 9 judges of the United States Supreme Court said so. Now you violated his due process rights, his constitutional rights, his Fifth Amendment rights, and I am supposed to treat him as if he's here in the States, and you're supposed to not facilitate domestic barrier removal, whatever that means, that gobbledygook. You're supposed to facilitate his getting out of the jail. And I don't care if that means you make a request, you write a letter, you actually, President Bukele, who cares about President Bukele? Last time I looked, we're in the United States of America. That's a red, white, and blue flag that sits behind the president, not the El Salvadoran flag. Well, we've got to respect El Salvadoran sovereignty. What do you mean? The Trump administration entered into a contract. Forget foreign affairs. This is not a foreign affairs case. Donald Trump desperately wants to make this a foreign affairs case because the Supreme Court left one stray line inside their order in which they said, well, be careful. You don't want to make an order that kind of infringes on the president's foreign affairs powers. Oh, it's foreign affairs. It's all about foreign affairs. Not foreign affairs. You wrote a contract. You signed a contract with El Salvador. You paid him $6 million. It's a storage unit for humans. It's a storage unit for humans that you happen to do offsite because it's cheaper. It's like a call center in India. It's not a foreign affairs. It's not delicate diplomatic dance between El Salvador and the U.S. Diplomatic dance? Has anybody seen the size of El Salvador? They're not our equal. I don't mean to insult the El Salvadoran people. I've got a lot of friends in Miami who are from there. However, they are not our equal. And the dictator president of El Salvador should not be telling us how to run our democracy or how to comply with our constitution. Should he? according to the Trump administration, they've completely delegated to Bukele how to comply. And the judge isn't having it. So when Drew Ensign sat there and started babbling away and reading, she said, that's not what the order says. Facilitate. Let me define it for you. That means you make a request if you facilitate his release. Not if he happens to show up, you give him a cup of joe and send him to another jail, which is what their argument is. She says, here's what we're going to do. There is a motion pending before me for contempt and a series of other remedies that the plaintiff's side wants me to enter against the government. I'm going to get a record developed. Now, see, that's what the federal courts need to do. That's the missing piece from corporate media. They're like, oh, she ordered discovery. That seems weak. No, it's strong. Because in order to be sustained and affirmed on appeal to her bosses at the appellate court, she needs a record, a factual record developed by witness statements and evidence and documents. And then she'll rule. So she has set a briefing schedule. She has set a discovery schedule. The government now has to sit for 4 different depositions and maybe more. Those are questions and answers, searing questions and answers under oath about what you've done to try to get him released and what are you planning to do. All 4 people or 3 people that filed declarations with the court every 5 p.m. as ordered by the court, they're now sitting for depositions of 7 hours or more apiece. And the judge told the plaintiffs, you can come back to the well. If you need more depositions, I'll give you more depositions. And if the government doesn't participate in good faith in discovery process, which is the exchange of information that I am ordering concerning the motion for contempt that's pending, then I'll entertain another motion for sanctions. And she told everybody, all the assembled masses in the room, who's in charge, who sits on bench on high, who's wearing the black robe. Drop down and give me constitutional compliance, in other words. She put on her glove. She said, we're doing 2 weeks of intensive, and I read that as proctologist-style discovery, right? And they're going to get their discovery, and we're going to make a record and cancel your vacations. That's what she told everybody and fought back. Now, let me read to you from the order, and I'll read to you from the thing that got her pissed off. The thing that got her pissed off was the unofficial transcript of that confab in Oval Office, jam-packed with all these cabinet members that Donald Trump forced to be there so they could all yell out, Stephen Miller, arr, arr. They could fight with Caitlin Clark or whatever. No, I'm sorry. With, the CNN anchor. It'll come to me in a minute. Put it in comments. So Pam Bondi could say stupid stuff out loud. And Bukele could say in his T-shirt with his suit jacket, well, why would I smuggle a terrorist into the United States? I don't know. Because there's a Supreme Court ruling that says the U.S. has to facilitate and you should send him back. I guess that's the reason. So here's the new, and then we have a declaration from Joe Mazzara. Remember Joe Mazzara. I'll be talking a lot about him in a minute. Let's go to the order granting expedited discovery that came off of last night's hearing. Here's what the judge says. It is well, let's start with what she says about there's been absolutely nothing to get Abrego Garcia out. On page 5, we'll kind of start from the middle and work backwards. She says, more fundamentally, this is the judge writing off of last night's hearing, defendants appear to have done nothing to aid in Abrego Garcia's release from custody and return to the United States to ensure, quote, as the Supreme Court ruled, that his case is handled as it would have been but for defendants' wrongful expulsion of him. Thus, defendants' attempts to skirt this issue by redefining facilitate runs contrary to law and logic. She says on page 4 or on page 3, she reminds everybody that the Supreme Court completely backed her. This court, in turn, ordered no more than what the Supreme Court endorsed, that defendants take all available steps to facilitate the return of Abrego Garcia to the United States as soon as possible, because bound within this remedy is Abrego Garcia's release from custody and the assurance that Abrego Garcia's case is handled as it would have been had it not been improperly sent to El Salvador. See, the administration on their Fox News softball interviews and on their talking points and on the campaign trail or whatever they're on, outside the courtroom are saying, he's not a Maryland resident. He doesn't have a green card. He does. He's not married to a U.S. citizen. He is. He's not here under a work permit. He is. He's not here under a proper anti-removal order to El Salvador. He is. He's an El Salvadorian, illegal. He's not. He was here under documented status. He holds a green card. And we're going to send him back to where he came from. Well, he wasn't born in the jails of El Salvador, so I don't think that works. But that's what we're watching. He's an MS-13 member. Yeah, I don't think he is. And I think the record needs to be developed in front of Judge Zinnes, the judge that we're talking about this entire time. She says in her order that she is going to order the following discovery, proportional with the request for a possible contempt finding. By no later than tomorrow, than today, by no later than today, Wednesday, April 16th, by 5 p.m., plaintiffs may propound, meaning serve on the defendants, the government, 15 interrogatories and 15 requests for documents. A quick tutorial. An interrogatory is a question and answer under oath in writing. It's in contrast to a deposition, which is done live in person. 15 requests for production. Give me all your documents about everything you've done. Give me all your documents about the contractual relationship between the U.S. and El Salvador for these storage units of people in the jail. Give me that. Give me all the things that support your position that this is some sort of diplomacy. Okay? So we'll do all of that. Also, by today at 5 o'clock, they will notice the deposition of Mr. Cerna, Mr. Katz, Mr. Kozak, and Mr. Mazzara. They all had the short straw of having filed declarations in this case, telling the judge to go F herself. Now they get to sit for deposition about what they know, if anything, about the arrest or the custodial position of Mr. Abrego Garcia, where he's at, what's his condition, how do they know that, and what have they done? What's the government done to get him out? By next Wednesday, if the plaintiffs need more depositions, the judge is going to award that as well. And then she said as well that after that, there's going to be, by Monday, April 28th, plaintiffs can amend their motion for contempt after they get all this new information and tell the judge they want more. The judge will entertain that. Final briefing will be April the 30th. And listen to this warning to the defendants, because she's told them she's not going to allow gamesmanship in her courtroom. She's not going to tolerate it. Consistent with that, here's the last line of the order. Should defendants, that's the government, fail or refuse to engage in the discovery in good faith, plaintiffs are free to seek separate sanctions on an expedited basis. Now, if I was a betting man, and what's the line, the gambling line on the Trump administration and the Department of Justice violating their good faith obligations to participate in this compelled discovery? And how quickly do you think, put the number of days in the chat down here in the comments, how many days from today do you think we're going to be back in court because the government has violated their obligations on discovery? That's what I want to know. And until then, I'm Michael Popok. You're on Legal AF. Hit the subscribe button. Yep. It helps us grow this pro-democracy channel in collaboration with the Midas Touch Network. And until my next recording, my next Legal AF contribution, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states. States and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok firm, fighting for your justice every step of the way.